My name is still Dan Fitzgerald, and I'm still the partner in charge of the Greenwich office of Cummings & Lockwood. If you're following along in the written materials, don't look ahead because you're going to ruin my joke. All right, do we have fans of the Family Feud television show here today? For those of you that don't know the show, the contestants are asked a question, and the participants have to guess the survey results to get the right answer. So I thought I would start today with a little Family Feud style question. And what are the top 4 questions we get asked as estate planning attorneys? So number 4, the survey says, can we do these documents on ChatGPT? Of course, the answer is no. While ChatGPT and AI are a slight upgrade from LegalZoom, the documents are still very rudimentary and not state-specific. And there's already been some malpractice cases filed where AI has been a total failure. The most made the New York Times. A litigator filed a brief with citations in it, and AI completely made up all of the citations. So discourage your clients from using AI for their estate planning. Next most popular question we get, how do we make sure the kids don't fight after we're gone? And there's a lot of ways to do that from the legal aspect, and any Cummings & Lockwood lawyer here today can help your client work through this situation. The bad news is if your client knows they're going to fight and you know that they're going to fight, they're probably going to fight. Second most popular question, and that's my topic for today, do we have to tell the kids about the trust? And what do we have to tell them? What if their spouse gets a hold of this information? So that's actually my topic, and we're going to work through what beneficiaries are entitled to with respect to trusts and how you can maneuver around that information and disclosure in drafting estate planning documents. And finally, I think you can all guess it, the number 1 question we get, how much is this going to cost? So to work through what do we have to tell the kids about the trust, I created a hypothetical family. We have Rick and Wendy. Rick has his son Jimmy. He's pictured here on the couch. Jimmy is 26 years old. While Harvard educated, he's currently bartending in Vail Village to maximize his time on the ski slopes. Wendy and Rick have a child together, Steve. Steve's only 4 years old. Rick wants to give $12 million to a trust for the benefit of Jimmy and Steve. And the question is surely to arise, what do we need to tell the kids about the trust? And so Rick and Wendy, like many other wealthy couples, struggled what to do. They want to use their exemption and save gift and estate taxes. They want to be generous with their kids, but they're also worried that the gifted or inherited wealth will disincentivize Jimmy or Steve, right? Jimmy might see it as an excuse to stay a ski bum instead of getting a real job. They also want to make sure Steve, who's only 4 years old, doesn't get discouraged from getting educated and becoming a productive member of society. But there's this inherent conflict, right? A trust is a fiduciary relationship where you have a trustee and a beneficiary, and the beneficiary has to have some right to knowledge and information about the trust to hold that trustee accountable for their actions. So the law is kind of figuring out what to do to balance that, holding the trustee accountable while still limiting the information available to beneficiaries. And so for the purpose of today's presentation, I'm going to break down 3 types of trusts. In the older jurisdictions that haven't updated their laws, we have what I'll call common law trusts, at least for today's talk. And then in some of the newer jurisdictions, we have silent trusts, and we have a third type of trust called a quiet trust. All right, so for the base point of the presentation, a common law trust. So these are trusts that are set up in states that have not adopted the Uniform Trust Code or updated their trust laws to make the modern sets of rules. And so when that comes to mind, New York is really the perfect example of a common law jurisdiction. Still has the common law rule against perpetuities, and its surrogates, Court Procedure Act and estate powers and trust law are really just codifying New York's case law that was already existing. So if you set up an irrevocable trust in New York, do you have to tell the kids? Do you have to tell Jimmy and Steve there is a trust in existence? The answer is not clear at all. There is no upfront duty to disclose the trust to the kids, and there's no initial obligation to send annual reports unless the governing instrument requires it. What is clear is that if Jimmy and Steve inquire as to the existence of the trust or certain transactions that have occurred, the trustee has a duty to respond in good faith. So if Jimmy gets wind of this somehow and asks the trustee for a copy, the trustee cannot say no. He has an obligation to keep the beneficiary reasonably informed. SCPA 2306 requires a trustee to provide an annual statement, but only if the beneficiary requests that annual statement. So this means if neither Jimmy nor Steve ask for the annual statement, nothing needs to be provided, unless in New York, if a trustee is taking commissions. So if a trustee is taking a commission, SCPA 2308 and 2309 require that a trustee provide an annual report to the beneficiaries. It is very clear in New York that you cannot write into the trust agreement that the trustee is prohibited from disclosing the existence of the trust. That case law has said that that is void against public policy. So in New York, in practice, what actually happens is Jimmy and Steve probably will have little to no knowledge of the trust unless they find out about it somehow, because the trustee will do whatever Rick and Wendy want. But that doesn't really give a trustee, and I know there's some corporate trustees in the room, a lot of comfort and clarity on what their disclosure obligations actually are. A lot of states have modernized trust laws, and certain states have gone as far to create what I will call a silent trust. So a silent trust is where the trustee is actually prohibited or restricted from informing a beneficiary for a period of time. These trusts right now are allowed in Delaware, Alaska, New Hampshire, South Dakota, Nevada, Tennessee, and Wyoming. If you're a non-resident, you have to use a trustee in that state to get access to those laws. So to deal with the conflict of keeping information from the beneficiary while also keeping the trustee accountable, all of those jurisdictions I just mentioned only allow the trust to be silent for a reasonable period of time. So each jurisdiction has its own rules, but most of it is tied to maybe a certain age, a term of years, a specific date, or a specific event. They cannot say it's silent for the entire life of the trust. So it's reasonable for Steve, the 4-year-old, for the trust to say Steve can't get notice until he's 30 or graduates college. But Ricky can't have the lawyer draft that Steve and Jimmy never get any disclosure about the trust at all. Where these silent trusts are permitted, it's difficult to actually administer an estate while staying silent. How does a trustee make a distribution to the beneficiary if the trust is silent? The beneficiary is going to get a K-1. Jimmy's going to get $100,000 of income. He's not making that bartending in Vail. Maybe he is, it's Vail. How does a trustee inquire to the needs of a beneficiary? A lot of corporate trustees require beneficiaries to submit budgets or annual tax returns. How can that process happen if the beneficiary is not even aware of the trust? So we have found in our practice it makes sense to have silent trusts where the children are young and the psychological impact of wealth could be most harmful, but once children are adults, it's really tough to keep a trust silent. So the last option out there is the quiet trust, and the quiet trust is different. How is it different from a silent trust? Well, a quiet trust requires the trustee to tell someone about the trust and provide annual reports to someone, but it doesn't necessarily have to be the beneficiary. In a quiet trust, a document will name a designated representative to receive that information in the annual reports, and it can be someone different than the beneficiary. The beneficiary might not know about the trust at all, but the designated representative is required to know about the trust and to act in the beneficiary's best interest with respect to the information and the reports they receive. The designated representative is legally empowered to act on behalf of the beneficiary if they want to object to anything or have a question about the trust. The designated representative has that power to do that. So for example, if a trustee wants to submit a formal judicial accounting, it's the designated representative that receives the notice. And if they consent or approve to the accounting, it's as if the beneficiary themselves consented or approved the accounting. The beneficiary would only then have a cause of action against the designated representative, but at least in Connecticut statute, the designated representative is not liable for anything as long as they acted in good faith. So Connecticut adopted the Uniform Trust Code in January 1 of 2020. So we are now able to do quiet trusts here in Connecticut. And so the trustee in Connecticut, as of January 1, 2020, is required to give a notice of existence to a trust within 60 days of the creation of the trust to either the qualified beneficiaries or the designated representative in the document. And so qualified beneficiaries are any person eligible to receive a distribution from the trust, or someone that would receive property from the trust if the trust terminated at that point. So when you set up a new trust in Connecticut, you have to tell people that the trust is in existence. These two rules really cannot be overridden by drafting. The one exception is the qualified beneficiary definition in Connecticut does not kick in until 25. So people under 25 do not necessarily have to get notice at the outset. So we have designated reps here now in Connecticut, so there's a few restrictions that are specific to Connecticut. A designated representative cannot bind a charitable beneficiary. Only the charitable beneficiary themselves or the Connecticut Attorney General can bind that beneficiary with respect to accountings or releases. You cannot use a designated rep to sign off for a charity. The designated representative cannot be the grantor nor the trustee. There's just obvious conflicts. You can't have the trustee and the designated representative be the same person and sign off on their own actions and keep the beneficiary completely in the dark. That's clearly not allowed. If the designated rep is a beneficiary also, they can't represent other people that are also beneficiaries unless the document specifically names that person. So now in Connecticut, Rick and Wendy can name someone else as a designated representative, say Ricky's brother, maybe Joe. So now Joe is getting the information, getting the initial disclosure that the trust exists, and potentially getting the annual reports that instead of giving it to Jimmy and Steve, they get to give it to Uncle Joe. And it's as if Jimmy and Steve receive that information directly. So some drafting tips for Connecticut trusts. Any new instrument should have at least a procedure for appointing a designated representative, even if you're not doing it at the outset. If you don't put that procedure in a new trust in Connecticut, we can't add it later by judicial modification, so make sure it's in the initial document. The most practical use we found of designated representative is cutting off information to the Gen 3 or Gen 4, right? So for Rick and Wendy, they set up a trust for all their descendants, Jimmy and Steve, or the children. Say Jimmy has a child, we can name Jimmy as the designated representative if we wanted to cut off information to the farther down generations. Finally, in Connecticut, we cannot have silent trusts. The designated representative and the trustee cannot be prohibited from not giving any information at all to the actual beneficiary. So I just spent all this time telling you about quiet trust and how to keep it silent or quiet, but there's one small caveat, and clients are always confused by this. When we talk about silent or quiet trust, these are functions of local state law, disclosure rules. This is completely distinct and different from federal tax law. And so when we talk about trusts and we use the annual exclusion, the gift tax, the $17,000 per year or $18,000 next year, we have to send a crummy notice to beneficiaries. And so that we can't override that at the state level and in the trust document. If you want to use annual exclusions for the trust, there's still going to have to be a crummy notice. And so clients that are thinking about silent or quiet trusts have to know that they're going to use their gift and estate tax exemption for their full gift. And so with that, thank you.